So let's get underway. I'm David Snyder. I'm the Executive Director of the First Amendment Coalition, and we are a nonprofit, nonpartisan group here in the Bay Area that advocates for, promotes, protects, defends the right of free speech, the right of the free press, and the right of the public to access government information. I want to first thank the Society of Professional Journalists Northern California for co-sponsoring this event, which is part of FAC's Subpoena Defense Initiative. That initiative connects journalists in need with pro bono legal counsel to help enforce shield law protections and fend off subpoenas, or in very rare instances, search warrants, as was the famous case with Brian Carmody, which I think we'll get into a little bit later today, last year. And also we provide these free workshops to lawyers and others who represent journalists. This program is targeted toward journalists, but I think lawyers could also and will also get a lot out of it. So one brief note for the journalists on this webinar, if you encounter a subpoena or you have any questions about subpoenas generally, or there's been a threat of a subpoena, please do contact us directly. There's information on how to do so on our website. And I also invite you all to join as a free member of FAC if you'd like to do so, or simply just sign up for our email updates. We'll circulate something after this panel that gives you some instructions on how to do so. And then two technical notes. Everybody on this webinar, except for the panelists, are on mute, but we welcome your questions. So please submit any questions you may have by way of the chat function, and we'll do our best to get to those questions. And also, we are recording this so that folks can watch it after the fact. So with that, I want to hand it over to Christine Peak, who is one of our panelists. She is the co-chair of the Freedom of Information Committee at SPJ NorCal, and she's a partner at the McManus Faulkner law firm in San Jose. Christine is going to tell us a little bit about the folks who will be talking today. So I hand off to you, Christine.
Thank you so much, David. Hi, my name is Christine Peak. I'm an attorney, and I'm also one of the two co-chairs for the Freedom of Information Committee of SPJ NorCal, which is a local chapter of the Society of Professional Journalists. Our organization, SPJ NorCal, advocates on issues that affect full-time news staff and freelancers alike. And the Freedom of Information Committee, as the name suggests, has a special focus on open records and open meetings. Thanks very much to the First Amendment Coalition for partnering with us on this webinar, and thanks so much to our panelists for taking the time to share their knowledge about the laws that protect journalists. So I'm going to introduce them briefly. We're going to have one more person joining us. There he is. So to go through, hi Ryan. Hey. We're going to go through and briefly introduce them, and then I'm going to give a little roadmap for our webinar today. So first, we're going to hear from Victoria Baranetsky, who's General Counsel at the Center for Investigative Reporting. Previously, Ms. Baranetsky was the First Look Legal Fellow for the Reporters Committee for Freedom of the Press, Legal Counsel at Wikimedia Foundation, and she served as the First Amendment Fellow at the New York Times. And she's going to get us started by talking a little bit about the First Amendment, as well as some of the gaps in terms of what the federal law covers. And that's hopefully going to give us some background and context to understand how California's shield law fits into the overall legal landscape. And then after we hear from Victoria, we're going to hear from Aaron Field, who is a media attorney in private practice at Cannata O'Toole Fickes Olson in San Francisco. His practice includes First Amendment litigation, public records litigation, and of course, California's shield law. He also recently completed a successful term as one of SPJ NorCal's Freedom of Information Committee co-chairs. So I have very big shoes to fill. And Aaron is going to dig into the who, what, when, where, why, and how of the shield law and give you some real world examples to illustrate how that law has been applied. And then after Aaron gives his presentation, we're going to hop back over to Victoria, and she's going to talk a little bit about the practical reality of being hit with a subpoena or other demand for information. And then after that, we're going to hear from Ryan Mack, who is a senior tech reporter for Buzzfeed News and is based out of San Francisco. And my SPJ NorCal Freedom of Information Committee co-chair and freelance journalist Lawrence Smiley is going to be asking Ryan some questions about his experience as a journalist who was recently subpoenaed. So as David alluded to, we will pause for questions at least twice during this webinar. So our first break will happen after Aaron and Vicky conclude their presentations. And then we're going to open it up for questions again after Lauren's interview with Ryan. And because this is a webinar format, we do ask that you use the chat feature. If you mouse over the bottom of your screen, you should see a button for chat. And you should also see that there's a pull-down menu that gives you the option to send your message to all panelists and attendees. So please at least send it to all panelists so that all of us can see your question. However, a note of caution, because we are using a third-party platform, be a little circumspect about what you disclose. Please don't share information that you wouldn't feel comfortable sharing generally. And do keep in mind that although the attorney panelists are talking about the law, they are not able to give legal advice to individuals in this setting. However, if you do feel that you need legal advice after this webinar, resources are available. So please feel free to contact me of us offline. So, and with that, I'm going to hand it over to Victoria.
Thanks, Christine. Good morning. It's just a privilege to speak with all of you today about this topic, especially given everything that's going on. And I'd like to thank FAC for organizing and for my co-panelists for informing everything that I'm about to say with much more alacrity and depth. Anyway, to get started, you know, what we're talking about here today is the shield law and reporter's privilege. So it's generally a circumstance where government officials or other bodies are trying to obtain access to newsroom information, often involving confidential sources. The subject has always been of great importance. You know, canonically, more than 150 articles authored by Bob Woodward and Carl Bernstein were based on unnamed sources. Within the last decade, the New York Times reported on the National Security Agency's monitoring program through confidential sources, and newsrooms across the country have reported on the interrogation tactics using them. And then more recently, since the Trump administration, confidential sources we know have been the base of many newsrooms reporting. In the past several weeks, COVID and the Black Lives Matter protests have also been informed by confidential sources. So there's little doubt as to the importance of the reporter's privilege. And it's somewhat of a misnomer in some sense, because the reporter's privilege is a privilege held by the reporter, but obviously used for the protection of the source. We would be amiss to not mention also the growing importance of this, given the technological changes over the past decade or more. In 2014, President Obama issued a report called Big Data, Seizing Opportunities, Preserving Values. And in that report, it talked about the rising, quote, volume, variety, and velocity of information growing in our society, and the importance of protecting that. And in that report, there was a section titled Insider Threat and Continuous Evaluation, where the government wrote about a growing concern over, quote, a string of troubling breaches and acts of violence by insiders who hold security clearances, including Chelsea Manning's disclosures to WikiLeaks, and the most serious breach in US history, the release of classified information documents by Edward Snowden. The report goes on and says, we must ensure big data analytics, power, and continuous evaluation are used in ways that protect the public, as well as civil liberties and private rights of those who serve on their behalf. So essentially, that report, right, highlighted that as data grows, as our information grows, there is a growing struggle between government and the media over information. We've seen this historically. As many of you know, the Fourth Estate has been on the losing side of this battle recently. In the 100 years since the Espionage Act of 1917, there have been a grand total of 14 prosecutions targeting leakers, but a majority of those actually came during the Obama administration. And in the first 6 months of the President Trump's administration, there was indeed one more. So, you know, these concerns from the government have been escalating since President Trump assumed office, initially the then Attorney General, Jeff Sessions, stated that criminal investigations into the sources and journalists were going up. And if asked if he would imprison a journalist, Sessions responded that it might make things easier. Obviously, in the past just few days with the assaults against reporters at various protests, there's an even more tangible concern. As Christine mentioned, I'm gonna delve a little bit into the sort of federal landscape or lack thereof around this issue. But before I hop into that, I kind of want to raise the tension that we all can kind of have in the back of our minds, especially for the reporters there, specifically what's at hand. And you probably know this better than any of the people even on this panel, right? But in the dissent in Brandsburg, an opinion that I will talk about very shortly, Justice Stewart was writing about the importance of the reporter's privilege. And he highlighted the tension between what the problem is for the source and for the reporter. And without a reporter's privilege, the source has to choose between risking exposure by giving information or avoid the risk by remaining silent, right? That's the basic thing. And then the problem for the reporter is the reporter has to speculate about whether contact with the source will lead to a subpoena. And in the event of the subpoena, if they have to choose between being punished in contempt for refusing to testify or violating their professional ethics and impairing their resourcefulness if they disclose the confidential information. So that's just sort of way of background of what occurs. Now I'm going to leap into the procedure and law in the federal landscape. So in the federal law, if there is a leak on the federal level, the government is bound to immediately take action to find the source and stop the transmission of the information. Sometimes the FBI and CIA can be brought in. Past administrations have used surreptitious methods like wiretapping journalists and trying to identify potential sources. President Kennedy initiated Project Mockingbird, right? President Nixon had people surveilling journalists. And as we know, most recently, President Obama had used methods to obtain phone records of journalists that were seized from the AP and Fox News. So procedurally, that's sort of the bomb that gets set off. But looming in the background is this case, which you've all probably heard about, Brandsburg v. Hayes, a case from 1972, a 5-4 decision. And what it was at issue there was actually 3 reporters who all had promised confidentiality to their sources. Relevant, in fact, to what was going on today, 2 of those reporters were reporting on the Black Panther movement and had promised confidentiality to members of that movement. And the reporters argued in that case that to gather news, it's necessary that they be able to gather information, not identify the source, and to not reveal those confidences to a grand jury. This case stands for one of the most confusing decisions that has come out of the Supreme Court, often contested as to what the ultimate meaning of it is. And part of the confusion comes from how the 5-4 split came. So the majority opinion written by Justice White starts out by saying, we do not question the significance of free speech, press, or assembly, right? He was very serious about the First Amendment protection. However, ends with the note that we cannot seriously entertain the notion that the First Amendment protects a newsman's agreement to conceal the criminal conduct of his source or evidence thereof, on the theory that it is better to write about the crime than to do something about it. In essence, White determined in his overall opinion that, in fact, there was no reporter's privilege in this circumstance. But one of the interesting things was that there was a concurring opinion that made it 5-4, written by Justice Powell, that said, that started off by saying the court does not hold that newsmen are without constitutional rights. And then in that, Powell actually discusses a balancing test, weighing judicial concerns around what is of paramount interest in the case. From that decision, there was varying confusion as to what to make of White, what to make of Powell. And in the civil context, various circuits decided that there would be a qualified privilege. The 1st, 2nd, 3rd, 4th, 5th, 8th, 9th, and 10th, and 11th, and DC circuits have all found a qualified reporter's privilege. We can go into this a little bit more in question and answer period. However, in 2013, a very important case called United States versus Sterling was decided. And there, the Fourth Circuit clarified that what Brandsburg meant. And it explained that in the criminal context, Brandsburg absolutely never confirmed a reporter's privilege. It also discussed that this interpretation of Justice Powell's opinion as conferring a reporter's privilege was not an acceptable interpretation. The case also highlighted that in the civil versus criminal distinction, in the criminal in particular, in that distinction, in that case, it's important because, quote, every man needs his evidence, right? And so the question is, do you allow the reporter to withhold information that's important in a criminal context? And there the Fourth Circuit said, absolutely not, because, quote, every man needs their evidence. And then finally, there was this question about whether there was even a common law privilege. So the court says, listen, there's no First Amendment privilege. Let's go to the common law and even examine that. The court went even further and batted down the opportunity of there being a privilege under common law. And so there are a variety of privileges in common law, right? Lawyer-client, psychotherapist-patient, husband-wife, communications with a clergyman. All of these are privileges that are recognized under the common law, and the court in the Fourth Circuit said, no, not even there. So this is perhaps to give you a better understanding, right, that this landscape that initially after Brandsburg, we thought that there was some hope, ultimately began to be whittled away over time under the shield, as to whether there's also a question of a federal shield law. Aaron will be going into the specifics of the California shield law, but there's no federal shield law either that exists at this point in time. While there have been several initiatives to have one passed, it has never passed both houses of Congress. The one sort of, and I'm gonna pass it off to Aaron in 1 minute, but the one sort of silver lining as to protections that exist on the federal level are with a non-official set of rules put out by the Department of Justice called the Media Guidelines, created in 1980, actually in response to a bureau chief that had their office raided. And the DOJ in response realized that, you know, maybe there should be some protections put in place and protocols to ensure that there wouldn't be First Amendment violations triggered. And so the DOJ put together these guidelines, and there are 3 major protections. And once again, this is just for federal cases involving the Department of Justice. And essentially there's a question of, can the material be got from alternative sources? Notice should be given to the reporters, and approval also has to be gotten from the Attorney General's office. As many of the people probably on this call remember, in 2014, when the AP's records were raided and Fox News correspondent James Rosen was identified in a search warrant as a co-conspirator to his source, the president at that time, President Obama, in fact, went back to the DOJ and said that there should be a review of these guidelines. And they were again strengthened there, but there have also been holes that we can talk about later during the question and answer period, most significantly involving national security letters. That is sort of one silver lining in what exists on the federal level, but that's why what Aaron is about to explain comes with such import because it is specifically these types of protections on the state level that secure both reporters and their sources. So I'll step out now. Aaron.
Okay, thank you, Vicki. So again, good morning to everyone. My name's Aaron Field, and I'm a media lawyer at Cannata O'Toole Fickes Olson in San Francisco. It's a pleasure to be talking with all of you, and I also want to thank everybody who helped make this happen and who helped organize this, the First Amendment Coalition, Christine and Lauren from SPJ, NorCal's Freedom of Information Committee. It's great to be here with all of you today and to talk about this important subject. So, as Vicki said, I'm going to be talking about journalist protections against subpoenas and searches under California law, including under California's Reporters' Shield Law. In a sense, I'm lucky to have that job because while Vicki kind of delivered some bad news, which is to say that your rights under federal law are imperfect, your rights under California law are substantially stronger, at least where in situations where California's protections apply. And so I'm going to be delivering that good news to you today. So we're blessed with powerful protections for journalists' unpublished information in California. And we're also blessed to have a Supreme Court, state Supreme Court that understands why they matter. We have a statutory and a constitutional shield law in this state, which is enshrined in both Evidence Code Section 1070 and Article 1, Section 2B of the California Constitution. And we have a Supreme Court that has recognized that what these rights do is they safeguard the free flow of information from the news media to the public. And our Supreme Court has described that as one of the most fundamental cornerstones assuring freedom in America. These laws were strengthened and enacted with respect to the statute and the constitutional provision, respectively, in response to the decision that Vicki just described, which is Brandsburg versus Hayes. So Brandsburg versus Hayes generated a lot of confusion about the strength of federal First Amendment reporters' protections. And in response to that, in California, the legislature amended Evidence Code Section 1070, and the people sometime thereafter voted to constitutionalize the rights in the Shield Law in 1980. I think the best place to start to give you a practical understanding of how the Shield Law works is with the settings in which California's Shield Law applies. So as Vicki sort of suggested, in federal courts where you have cases involving federal law, the Shield Law in the California's state Shield Law generally does not offer protection. But it does broadly offer protection in California state proceedings. So in California judicial, legislative, and administrative proceedings, in other California proceedings in which subpoenas can be issued, and in some federal proceedings in which California law provides the basis for the proceeding. So sometimes you have a litigation between people in different states that might be based on state law, but that might be worth more than a certain threshold. That can get you into federal court, even though you're dealing with an underlying issue of state law. In that situation, you might also get some of the benefits of state protections. So with that said, to delve into the substance of the Shield Law, I think a good place to start is what information it covers, just as a baseline for understanding how it works. So you probably already know, and Vicki already suggested, that the Shield Law covers your confidential sources. So it protects the confidentiality of confidential sources. But in California, it's actually substantially broader than that. It also protects any unpublished information obtained or prepared in gathering, receiving, or processing of information for communication to the public. So that includes not only confidential source information, but even information that you obtained in public that might be otherwise publicly available, so long as you aren't the one who published it. And it can even include non-confidential eyewitness observations of an occurrence in a public place. This is important, especially now, because I know that a lot of you have probably spent the last few days reporting on the protests that have been happening all over the country. Those protests occurred in public places. You may have witnessed any number of things at those protests that folks might be interested in trying to compel you to disclose. Much of what you have seen is at least provided with some protection under the Shield Law. And we'll talk about how that protection works in a few minutes with respect to different categories of information. Another way to illustrate the protective scope of the Shield Law is to consider another example in which it comes up a lot, which is where someone's covering a criminal prosecution or a criminal case. In those cases, a journalist might conduct a jailhouse interview or an interview with someone in a public place. The content of the interview might not be confidential in a normal sense, but regardless, if you choose not to publish portions of that interview and your observations during the course of that interview that you choose not to publish are entitled to some shield law protection. And so anyone trying to get that is going to have to surmount the shield law, or it will just be unavailable to them. The shield law, to understand its strength and sort of from a baseline level, the shield law is written in terms that are quite absolute. So the shield law provides that journalists shall not be adjudged in contempt by a judicial, legislative, or administrative body, or any other body having the power to issue subpoenas. And because contempt is generally the only effective remedy against a non-party witness in at least civil cases in which a journalist is not a defendant, the shield law often provides virtually absolute protection in that context. So the shield law, there's also a related law that's worth mentioning, and that's probably at top of mind for many of you, given everything that happened with Brian Carmody last year, which is Penal Code Section 1524G. This provision says, using language that's similarly absolute to the language of the shield law, that no warrant shall issue for any item that the shield law protects. And so as a result of that, prosecutors and government officials can't use a warrant, a search warrant, to get around the protections that are enshrined in the shield law. And really, if they want to access information that is subject to the shield law, even in the few instances in which someone might think they have a right to do so, someone has to try to do so using a subpoena or a more tailored method than a search warrant. Search warrants are far more invasive than subpoenas. That's part of the reason why this is important. Police don't have to necessarily give you notice in advance of executing a search warrant. They could theoretically search without notice. They can seize your items and search your items in a much more wide-ranging way, your digital devices, your notes. So absent the shield law, if it were a sort of open season on search warrants, that would be highly problematic. The shield law simply prevents that from happening. The shield law, it's also useful to understand why the shield law covers both non-confidential and confidential information, and just what the importance is of keeping journalists from being forced to testify in proceedings. So confidential information, confidential source information, Vicky already eloquently explained. Really, sources would be chilled from providing controversial information in some instances if their identities were revealed. You know, we all, I think many journalists like to be hesitant for good reason about conferring promises of confidentiality on people. We're not going to go into all the consequences of conferring such promises, but it's important that you have the right to do so in the appropriate circumstances. That's why it's important that the shield law protects those confidential source relationships. But the reason to even protect some non-confidential, unpublished information from being exposed is that you don't want, I mean, it's at least fourfold, but you don't want journalists to start to seem like they're arms or agents of the state for any number of reasons. One reason is that discourages individuals and members of the community from speaking with journalists and working with them. You don't want to disincentivize journalists from taking good notes and compiling research materials. If journalists' notes could be easily subpoenaed, then journalists might not take notes in the same way, and that might be an obstacle to effective reporting. And also, being subject to regular subpoenas just is burdensome as a general matter. Having to collect documents and provide them upon request is an additional burden on newsrooms, and I think we all know that newsrooms are burdened as it stands and don't need those additional burdens now. That in itself is an important reason to ensure that journalists are protected from having to testify, even as to non-confidential, unpublished information. In California, there's one more reason to think about. If you're forced to testify in a case, there's an evidence code provision that might sometimes allow the court to kick you out of the courtroom. Basically, the idea is that if you're a witness, the courts don't like the possibility of you coordinating your testimony with the testimony of other witnesses. And they're concerned that your testimony might be tainted by others' testimony. This is obviously a problem if you're trying to cover an entire prosecution or investigation from its inception through the trial. In that circumstance, you want to be present for the trial, presumably to continue reporting on what happens. If you're somehow forced to testify, obviously you wouldn't be able to do that. So that's another reason why, or at least under some circumstances, that's another reason why it's important to generally protect these kinds of information. So the test for invoking the shield law doesn't only hinge on the type of information at issue. A journalist to invoke the shield law also has to be one of the types of persons enumerated in the law. And the journalist also has to be able to show that the information sought was obtained or prepared in gathering, receiving, or processing of information for communication to the public. In other words, during the news gathering process. So first, I think we should talk about who's covered by the shield law. The shield law is pretty broadly written, but it's not completely broadly written. So it provides that it applies to a publisher, editor, reporter, or other person connected with or employed upon a newspaper, magazine, or other periodical publication, or by a press association or wire service, or any person that has been so connected or employed. It also extends that protection in a separate provision to radio and television news reporters or people who have been connected with or employed by radio or television stations as well. There's not a ton of case law interpreting the outer boundaries of the shield, of this portion of the shield law, but there is some, and we can be confident at least that freelance journalists are protected by the shield law. They're considered to be connected with a publication or a radio or television station. And the protections of the shield law have been applied in at least one case called People versus Von Vies, both before and after a contract for publication has been entered, or to information gathered both before and after a contract for publication has been executed. So even before you sign your contract with a news organization to do this article with them, information that you've gathered for the purpose of disseminating to the public through this sort of usual freelance journalism process would generally be subject to protection under the shield law. The format of the publication is not supposed to matter. There, again, isn't a ton of case law on this, but one case that speaks to this issue concluded that a digital news organization was just as protected as a print one. Basically said they can't think of a workable test or principle that would distinguish legitimate from illegitimate news, and that attempts to draw such a distinction would imperil a fundamental purpose of the First Amendment. The Carmody case is a good illustration of the scope of the shield law. So Mr. Carmody is a freelance journalist based in San Francisco, and in their attempts to get search warrants targeting Mr. Carmody, and by the way, they got these search warrants in connection with the leak investigation, San Francisco police noted that Mr. Carmody, according to their searches, wasn't applied by any public-facing, or wasn't employed, excuse me, by any public-facing news organization that ended up publishing some of the information that he was argued to have obtained. They sort of suggested, by citing that fact in that way, that that fact was important. But we know from People versus Von Vies and from other similar cases, there aren't many, I think there are one or two other similar cases, that freelancers, though, who by definition are not actually employed by a public-facing news organization, are in fact covered. So eventually those warrants obtained targeting Mr. Carmody were quashed and were considered to be unlawful as a result. With respect to the obtained during news gathering portion of the test, this portion of the test also obviously includes edge cases, and there's even less case law interpreting this part of the test than the previous one. You can imagine lots of situations when it's not necessarily clear whether what you're doing is in the course of reporting the news or in the course of doing something else, especially in our world where we're sort of always connected to our workplaces. It's sometimes very hard to draw that line, and it's not clear how courts would draw it if that line were tested in court. We can be informed by what the California Supreme Court said in one case. It said that a reporter who, say, wanders into a liquor store on his way home from work and witnesses a holdup could not invoke the shield law and refuse to testify. Off the job, a journalist is no different from any other citizen. But again, it's really not clear when a journalist might or might not be considered off the job So there's room for litigation there. I know no one likes to hear that, but that's where we are with that requirement. In any event, the more clearly on the job you are when you're engaged in news reporting, the more protected the information that you obtain is going to be. So there are a few ways to pierce the shield law under some circumstances, although it's often difficult or impossible, at least in the context of California's state judicial, administrative, or legislative proceedings in which you're not a party to the case. So in civil cases in which you're not a party, under a case called New York Times Company versus Superior Court by the California Supreme Court, you essentially have an unqualified protection against subpoenas by the party targeting shield law protected information. So that means that the parties basically can't get at that information using a subpoena. They can't use the contempt power, at least, to force you to disclose that information. Somewhat similarly, in a case called Miller versus Superior Court, the California Supreme Court held that prosecutors can't force you to disclose information protected by the shield law in criminal prosecutions in which you're not a party. Basically, it cited that prior case. It said the terms of the shield law are absolute, and there's really no justification for that's cognizable if the prosecutor is the only one asking for the information, at least, for allowing the prosecutor to overcome the shield law's protection. So one area of weaker protection that it's good to be mindful of is when a criminal defendant is the one trying to get the information. A case called Delaney versus Superior Court from the California Supreme Court discusses this situation. If a criminal defendant is trying to get your unpublished information, despite the language, the absolute language of the shield law, the criminal defendant might be able to overcome it. And the reasoning is criminal defendants have a countervailing federal due process right, or federal right to a fair trial. So not a due process right, although perhaps incorporated into the states through the due process rules. But in any event, criminal defendants have a fair trial right. Sometimes that entitles them to information, notwithstanding the shield law. There's a balancing test that governs when a criminal defendant can pierce your shield law protections and get information. First, a criminal defendant has to show that there's at least a reasonable possibility that the information will materially assist her defense. The showing doesn't have to be detailed and specific, but as the court in Delaney said, it has to rest on more than mere speculation. And once that threshold showing is made by the criminal defendant, the court engages in a further balancing test. So it considers whether the information sought is confidential or sensitive, whether protection would further the interests protected by the shield law, the importance of the information to the criminal defendant, and whether there are alternative sources for the information. In Delaney, which involved a situation where two LA Times reporters saw something in public, the court ended up requiring the LA Times reporters to testify. But that stated, the fact of the matter is that the test set forth in Delaney for when criminal defendants can force that kind of testimony is rigorous, and a good attorney may be able to defend against even a claim for information made by a criminal defendant. It's just that some litigation might be required. There's one more caveat. And the caveat is that if a criminal defendant is the one asking a journalist to, if a criminal defendant asks a journalist to testify about published information, and it's important to note, published information is not covered by the shield law, so you might end up having to testify to simply verify that something you put into your article is in fact true, then the prosecutor may, after all, have a right to cross-examine you about unpublished information that might undermine your testimony about the published information. So this is sort of a backdoor way around the Miller versus Superior Court general bar on prosecutors getting your unpublished information. But again, if the prosecutor is the one initiating the request for information, the prosecutor is not supposed to be able to get your shield law protected information. It's just if the defendant brings you into the case, then the prosecutor may have an avenue to get at that information as well. But even then, the prosecutor has to show that the Delaney test is satisfied, the balancing test still applies, and that balancing test still gives you a significant amount of protection. It's just that your protection in these cases is not absolute. I'm not going to go into all of the details of what happens when you're an actual party to a civil case today, but there's also a separate balancing test that applies and governs whether you have to turn over information if you're, for example, a defendant in a libel lawsuit. That's sort of the classic situation in which a reporter might be made a defendant in a civil proceeding. There's another balancing test that says, well, maybe you have to disclose information that would otherwise be shield law protected in that situation. It's a case-by-case test as well. And if there are questions about that, I can go into more detail about it. Presumably, though, you'll already have a lawyer if it gets to that point, and so they can counsel you on more specifics. Though I'm, as I said, happy to provide a little more in the question and answer period if you'd like. In terms of how to fight requests for information when you get them, if you get these requests informally, I think just knowing that the protection is pretty much absolute in the context of civil cases is good. I think because then you can simply cite that New York Times Company versus Superior Court case. That will generally be the end of the matter. If you have counsel, you should have your lawyer do this for you. It's better to navigate these situations with counsel, in part because the shield law world can be complicated, but there is a lot of protection in the context of civil proceedings in which you're not a party. The same goes for that Miller versus Superior Court case if a prosecutor is the one who's initiating the request for information. If the requester is a criminal defendant, like I said, it's going to be a little more complicated. You can cite the Delaney case and the Delaney test to the criminal defendant, and that might be the end of the matter, but it might not. It depends on the circumstances of the case, whether you'll need to litigate that issue. I have had success fighting off subpoenas by criminal defendants. It can be done. Talk to FAC and the Subpoena Defense Project that it has, for example, if you need help with that. Good lawyers can help, but it's just something that you might have to fight a little bit harder on. You should still know, though, there are still substantial protections. There are also technical requirements in California that specially apply to subpoenas directed at journalists. Under Code of Civil Procedures, section 1986.1, you're supposed to be given at least 5 days of notice before you're hailed into court to testify. With respect to subpoenas directed at third parties that might have your records, though you're also supposed to be given at least 5 days of notice before those third parties are allowed to turn over your records. And that notice is supposed to include a statement of why this information is needed, what the justification is for the party seeking it, getting that information. These might seem like really simple, easy requirements, and they kind of are, but they're potentially useful because a lot of lawyers just don't know them. They're requirements that are special to the journalist subpoena context. And as a result, the lawyers seeking information from you may simply not know about them, not comply with them. Our practice at my firm is generally to raise an objection with the counsel seeking your information or trying to force you to testify. We don't necessarily always go to court to file a motion to quash, although sometimes we would. There are ways to get courts to simply invalidate a subpoena, but you don't necessarily need to go that far. Sometimes simply sending an objection to someone that's based on one of these really powerful cases that we've talked about, New York Times versus Superior Court or Miller versus Superior Court, will be enough to get someone to go away. And so I know that was a long discussion of your rights under the shield law, but I hope it was helpful. And I want to give Vicki time to discuss her real world experiences dealing with requests for information as well. But thank you all for all of your great reporting. And I hope you find this helpful in continuing it.
Hi all, thanks Erin, that was so amazing. I'm gonna just chime in with a few experiences that we've had inside our newsroom that I hope will also give a little bit more practical guidance and help. And then I think we'll open it up to questions after that. So the first thing to just sort of step back is, discuss is, what happens when a request for information has been made. And Erin touched base on that a little bit, right? But one of the things that as an attorney you look at, is who's issuing the request, what jurisdiction they're in, and then what privilege applies. And so that's how you sort of sort it out. And for a newsroom attorney or an attorney like Erin, who helps a lot of reporters, you can quickly bat away a request made by a government agency or other body just by simply responding. And so in our newsroom, we've had several instances where reporters have been contacted by government bodies, and then immediately they bring that to my attention, and I have a very quick conversation where, you know, it dawns on them that perhaps given the law that it's an inappropriate request that's been made. The people who really are more in a place of concern are freelancers without that institutional protection, as the case by Brian Kermody illuminated. Not that the law doesn't protect freelancers, it certainly does, right? There's a case, People versus Von Villis, from 1992 in California that explicitly, squarely states that freelancers have been long protected. And Brian Carmody certainly was, but it's especially important that you guys have the First Amendment Coalition number on hand and reach out to them the moment something happens. And I know that Brian Carmody did in fact reach out to the First Amendment Coalition and David Snyder, which is why he was able to get such immediate, quick response. So, you know, when something like that does happen, contact your attorney right away. There are certain things that have to take, you know, an attorney also has to do, you know, make sure that what the materials are that are being looked at, how to protect them and so on. But your attorney can guide you through that process, and the First Amendment Coalition is a great contact for that. The other thing to think about that comes up pretty often in my newsroom is, you know, the relationship between you, the journalist, and your sources. So, you know, you have this reporter's privilege. And what are your obligations to the source, right? And part of that is you being clear as to what your promise is and what your engagement is. And that promise can change over time as to what you're promising to protect. But this is something I often talk about with my reporters, right? Are you promising to protect their name, their confidentiality? Are you promising the protection of everything that you've written about? That's something to keep in mind as to what is your promise to the source, because there is also a law in California as to, you know, a source could bring a claim against you if you have broken your promise to them. And so always being clear as to what that promise is. That in addition, as a reporter, when you do talk to an attorney, right, when we are talking about the reporter's privilege, we're talking about the privilege afforded to journalists to protect the source. But the source is protected behind your shield. But that doesn't mean that legally the source would be represented by your attorneys. And so if a source, you know, does want that extra protection, I always make clear to the reporters that, you know, they need to be clear with their sources that their legal concerns are different than your legal concerns. There's a wonderful organization called the Signals Network that is run by Delphine Halgand. And there's also the Government Accountability Project that has legal resources for sources in particular, which is worthwhile noting. The third, before I get to the fourth and final note, is just the technology around this, right, is ever more important. What we're talking about here today is the legal terrain, but the technology is in some ways even more important than the legal reality, right? And speaking of reality, Reality Winner, right, who was the source for a major story written by The Intercept, her identity was released in part through the documents that The Intercept published. And from there, the government could see the notation on the electronic transmittal of the documents that were published online and able to identify the source. So it's really what I started off talking about at the beginning about the growth of information and data, as more and more of that data lives in an electronic format and in the ether, on the internet. It's important that we make sure that reporters are maintaining their promise to their sources, not just through the privilege, but actually through these other ways through which governments and others can subpoena third parties for reporter information. So for example, putting in your calendar, you know, if you're meeting with a source, not putting their direct name or their phone number, putting in some kind of anonymous name. Julia Angwin at The Intercept, when they reproduced slides that they got from a confidential source in Facebook, they reproduce the slides wholesale rather than publishing the slides because there's metadata on all this information. Similarly, if you go to protests, if you're covering protests, making sure that the data is off on your phone so there can't be any transmittal of information that way. So those are just, you know, there's a lot more to discuss there, and there are organizations like Freedom of the Press Foundation that are really ripe for, you know, giving more detail as to all those things. But that's something to really keep in mind because, you know, subpoenas and shield laws are still relevant, as the Carmody case showed. But really, what we worry about now mostly is actually how this information can be obtained through third parties, through a reporter's Google accounts or Twitter accounts or other electronic formats. The last thing I'll note, and this is really a much bigger topic of conversation, but at the Center for Investigative Reporting, one of the things that we recently dealt with subpoenas this past year was in a defamation lawsuit that we are actually battling, brought by a organization called Planet Aid. Our reporter, two reporters of ours wrote a story about this organization and how they were obtaining funds from US government grants as well as other international bodies. And the lawsuit was brought by Planet Aid, which we maintain is frivolous and vexatious. But there, Planet Aid used subpoenas to obtain the journalists' reporting as a mode of discovery in the libel lawsuit to try to show whether there was actual malice held by the reporter. And this past February, just several months ago, we did have an order come from the court stating that, you know, the court would not compel the names of sources because it was preliminarily, at least, potentially covered by the reporter's privilege. But there were some emails that the court did say had to be disclosed. And the question there, it's a qualified privilege, right, under federal law, but are there other alternative sources to get this information? Is it cumulative, meaning is it repetitive, and is it relevant to the issue in the case? And in a defamation case, it's the actual malice standard. I'm just raising this because obviously there have been a massive rise in defamation cases around the country. And so this is an area where I think the subpoena issue and shield law will become more and more relevant. So I think that's it, and I'll bow out and leave the rest for questions. But thank you so much, everyone, and yeah, here for your comments and whatnot. Stay well.
That's great. Thank you, Vicki, and thank you, Erin. We do have a few questions. There is one that went out, and we sent a link in response to it to an article from the Reporters Committee for Freedom of the Press. But in case, for whatever reason, you might not have been following the comments, I just wanted to highlight it and see if we can address that for the group. So the question was, can the panelists address the applicability of the California Shield Law to sources that are not physically located in California, as many reporters cover stories nationally, and their sources may come from all over the world. So could anybody talk a little bit about that?
I think there's a whole separate universe of law about when a state's laws apply, you know, when California law would apply as to the law of another state. I think it depends on a balancing of interests as I remember it, and I don't know that there's a bright line rule that I can confidently share now. Certainly, if your source is in California and the case is in California, it's likely that the California Shield Law would apply. But in terms of outside of that, I'm not sure I am able to answer at this point.
No, I think that's fair. I'll just echo that choice of law issues can be very complex.
Yeah.
Certainly, you would start off with your strongest possible argument for the strongest possible protection, but I agree with what Erin said.
I would just add that, you know, remember that what we're talking about most is subpoenas to journalists. So it's a subpoena seeking information from the journalist. And you're right, Aaron, that the choice of law could come into play. But I think the key variable isn't really necessarily where the source is. It's where the lawsuit is filed, whether it's state or federal court, and where the journalist is located, right? So that's not a much clearer answer. I think, but again, the key variable is kind of where's the lawsuit filed? Is it California state court? Is it California federal court? Or is it filed in Tennessee or somewhere else?
And to add to that, it's also where the subpoena is issued. And so sometimes jurisdictionally, you can actually kick out a subpoena if the jurisdiction doesn't apply to yours. So a state doesn't necessarily have the ability to reach its hands over into California if it's from Missouri or whatnot. And so actually many subpoenas in newsrooms are actually swatted away on jurisdictional grounds, which is a very valid point to bring up. And another way that journalists, if they have a attorney on hand like FAC or otherwise, could quickly identify that and just push it out that way.
Excellent, thank you guys. I have another one for you, since we are in a time where there's unprecedented levels of public participation and First Amendment expression. We did get a question in this context. People want to know, does the SHIELD law affect news reporters at protests? And can you talk a little bit about how the law could potentially be implicated in that context?
Vicki, do you want to take a stab at that, or would you like me to start? Yeah, go for it.
I think that this is a very, very relevant question. Eyewitness observations to quote crimes are precisely the type of ways that subpoenas can come in. There's a case, Dillon versus the city of San Francisco from 1990, denying a cameraman's motion to quash after he had personal observations, and the court found that was actually not privileged. There are other kinds of cases like this that that are replete in California courts, and I think that's one of the main ones. And it's important because in that case there was actually a beating of a citizen by 2 police officers, and the reporter had to testify. The case, it depends obviously very much on what the facts are, what the information is trying to be obtained. Was it done in the course of reporting? Is it material or is it testimony? All these things would vary in terms of, so I'm in no way explaining what the outcome would be, but simply just saying that it's incredibly relevant right now with protests. And that's also why one of the things that we noted earlier was the technology aspect of this, and just having very healthy technological hygiene is important to make sure that the information that you carry. So I was just talking to a National Lawyers Guild attorney yesterday, and we were talking about ensuring that all the equipment that you carry, if possible, has encryption on it. That you don't have your phone so that you can just do a face recognition or a thumb recognition, making sure that the information is secure, that it's not, that the data is off so it isn't going to be intercepted some other way. These are just some of the ways that this is absolutely relevant today. Aaron, you might have more to add.
No, I mean, I think that's exactly, I think you're right, that protests are a situation in which the SHIELD law is implicated. We know from just looking at that seminal Delaney versus Superior Court case that eyewitness observations in public places made while news gathering constitute, at least if you're a covered, one of the individuals enumerated in the SHIELD law, something that California's SHIELD law at least protects. So one thing that journalists have witnessed a lot of really beautiful expressions of support for important causes, but they've also witnessed some crimes, right? And so that's a situation in which it's possible that someone might want a journalist to provide information about what they've witnessed. It's definitely a core situation in which the SHIELD law could come into play. So it's something that is very relevant in the protest context and the protest reporting context. And it's certainly worth thinking about for that reason.
And I would just quickly add that another way in which the shield law could become relevant in the protest context is if a journalist is detained and the authorities who detained or arrested the journalist attempted to take their notebooks or their cell phone or whatever. So you'd have a kind of situation similar to what we saw with Brian Carmody, where they might try to or actually seize records that the journalist has on their person. And in that instance, it would be of crucial importance for that journalist to have a lawyer explain very, very quickly to the police who arrested the journalist that they're not entitled to look through any of that material, and that it's very important that they don't.
And here's actually a little tip, which is that a lot of media in-house counsel have recommended, actually, if you go out into the field with equipment, that you put on the equipment property of, and then you write the newsroom's name, and then also include then the name of your attorney on them. And so once again, this is one of those situations where freelancers get sometimes a shorter end of the stick. But I think another thing you could do, saying this is a journalist's, you could write a thing and tape it on. This is a journalist's piece of equipment. I don't mean to step out of line here, David, but I imagine they could say, if seized, immediately contact FAC or another organization that would be willing to help NLG pro bono, putting that sticker onto the actual equipment to ensure that there is definite notice given to the police that they should not be seizing or invading or opening this material without consent. I know that some newsrooms have gone as far as to actually say that that it's trade secret material too, that it's confidential trade secret material to the newsroom. So that's an interesting use of that line of legal thought as well.
Yeah, that's a great thought about putting sort of notice on the equipment. I mean, I've been in a situation where as lawyer, not when I was at FAC, but previously, we were in a mad scramble to figure out which agency had the camera materials at issue and to contact them. It was like 11 o'clock on a Friday night, because it's so crucial that you just get the word across to the investigating agency that they're not entitled to look through any of the stuff that they seized. Because once that toothpaste is out of the tube, it's out of the tube. You could have material in a device that is really important and could divulge sources, maybe not even for anything that the investigating agency is interested in. But once it's out, it's out.
One other note, this is just a totally practical matter, but in speaking to this NLG attorney yesterday also, because of COVID, most reporters are not being, most people being arrested are not being put in jail because of COVID. So they're going through a processing period that takes about 8 hours or so if they are being arrested. They're only being arrested and put in jail if there is a physical or a physical crime being conducted. But most people being arrested are therefore then being let out. But in some circumstances, they are sometimes being dropped off in odd locations. And so some advice I heard, which is not entirely related, but good for your safety to know, is just making sure that all of your equipment also is charged, that you possibly also have a charger on hand for your equipment, particularly your phone, so that if you are dropped off after a late hour, you can contact somebody, and even possibly having change on hand so that you can contact individuals.
Okay, thanks everybody for your answers and your thoughts on those questions. I see we do have some coming in, but we're right up at a little bit after 12:30, and I want to make sure that we do get a chance to hear Lauren's interview of Ryan. So with that, I'm going to turn it over to Lauren and Ryan, and then we can reopen it for questions afterwards.
All right, thanks so much. I'm Lauren Smiley. I'm a journalist here in San Francisco and also the co-chair of the Society of Professional Journalists Northern California Chapter Freedom of Information Committee. So let's just jump right in here because we have limited time here. Yes, so I'm sure we're all excited to hear from Ryan today about his experience while reporting on Elon Musk's defamation suit for Buzzfeed. Ryan is a senior tech reporter at Buzzfeed, and he got into a situation that's been well covered in the press, but he's going to talk to us about his experience today. So Ryan, let's just jump in about the setup of this story. So for anyone who doesn't know the outlines of what happened in this news story, can you give us like the Cliff Notes version of how you ended up getting these sort of spicy emails from Elon Musk in your inbox?
I feel like this is like its own like day worth of panel, but yeah, it happened in 2018. Basically, Elon Musk was having this situation, like a pretty bad summer with pressure at Tesla, and he gets involved in this cave rescue in Thailand. These kids were trapped in a cave. They were in some pocket of air in the cave, and people were trying to figure out how to get them out. He inserts himself on Twitter, as he sometimes does, and volunteers to help get these kids out, and decides for whatever reason to help build the submarine, which isn't used in the rescue, which I'm sure people have read about. Following that, the kids were eventually rescued and saved, and one of the rescuers involved in the actual rescue of the kids, who was involved in the planning, gave an interview to CNN where he criticized the tube, criticized Elon Musk, called it a publicity stunt, and essentially triggered Elon to say some not nice things about him on Twitter. He called him a pedo guy, insinuating that he was a pedophile, which led to this whole back and forth, a lot of criticism of Elon, and just a deluge of issues for him. Fast forward a couple weeks later, he doubles down on the comment, triggering me to ask him why he had called this guy a pedo guy in the first place. And he sent me these emails that became the subject of a story that I was eventually subpoenaed over.
Yeah, so as a reporter, first of all, talk us through a little bit what the email said. I've put in the chat for everyone the articles about this and some documents there for you all to reference. But yeah, talk about the emails and just what you did as a reporter and what you thought when you got the emails from him.
Yeah, it's a lot to digest, actually. Now that I'm like just explaining it sounds kind of bizarre, but in the email that he sent to me, I basically asked him, on his personal email, why did you double down on calling this guy a pedophile? He emails me back. To my surprise, I didn't really expect that he'd email me back, but he called me a fucking asshole and asked me why I was defending a child rapist, and insinuated something about the guy having a 12-year-old bride. Email was interesting because at the top he had labeled it off the record. There was no agreement for us to go off the record. I had an off the record agreement is someone asks to go off the record, the journalist or the source then agrees, and then we go off the record. There hadn't been any agreement like that. And so when I was reading this, it just occurred to me that it was clearly fair game. It was on the record. It was publishable. And we ended up publishing a story on that, on what he said about this guy.
Yeah, you did some like quick vetting of what he was saying, that like your greater concern was like whether it had any merit for him to be saying these things about this caver.
Yeah, it was, I mean, first of all, I was like in shock for like an hour after he sent me it, because it was just like this email, a very long email outlining these very like specific things about this cave rescuer, and a bunch of follow-up back and forth between the both of us. But we decided that it was newsworthy from the start. I mean, here was a very powerful individual, the CEO of two major companies, SpaceX and Tesla, who were making these kind of unfounded accusations against this rescuer, this guy that was a hero who had saved these kids or helped save these kids from a cave. But at the same time, we also wanted to vet some of these allegations and do our basic reporting on it. So I remember getting the email, I think it was on a Thursday or Friday, and just spending the weekend, it was a 3-day weekend, like reporting that out and figuring out if any of that there was any hint of kind of truth to anything that he said. There were some very specific things. We ended up calling like the embassy, the Thai embassy, the consulate, trying to suss out if there was anything worth reporting here that was truthful. After making a determination after a couple of days, we decided that there was really nothing there that Elon said that was worth, or that was, I guess, news or truthful, I guess.
Mm-hmm.
And we kind of decided to frame that story around him making these unfounded accusations against this guy.
Yeah. So, and were you at all worried that these emails, like, did you doubt their authenticity at all? Were you like, is this really Elon Musk sending me these emails? Or?
I mean, it's so weird. I mean, I emailed him not expecting a response, and get this like 4 or 5 paragraph, almost like essay type response that leads with "you fucking asshole," basically. Which is always a great thing to read in your email inbox. But yeah, I mean, I like did a triple take at it. You know, like I checked the subject line, I checked the sender to make sure it came from the same email, to make sure that someone wasn't trolling me here. But it was very much him sending that email, and of course we made the requisite calls to Tesla PR and stuff like that.
Mm-hmm, mm-hmm. So eventually this caver sues Musk for defamation over this pedo guy stuff. And then you and Buzzfeed sort of got caught in the crossfire of discovery within this lawsuit. Can you talk about like when you got notice that you were getting subpoenaed into this defamation case?
Yeah, it was strange. So yeah, there was initially no movement on a lawsuit from the initial tweet accusation. I think there was like a letter that the caver's lawyers sent to Musk that he posted on Twitter, actually, too, in like one of Elon's mentions, and it was like, we reserve the right to sue you if you continue to say these things. There had been no kind of lawsuit filed prior to Elon's email to me, and when that email was sent, and our story published, a lawsuit was then filed. Large, I guess, in part because of, I guess, the doubling down of on the accusations that was sent in the email. And I guess mm-hmm. Elon went a lot further in the emails than he did on Twitter in talking about Vernon Unsworth, the caver. And so, yeah, the lawsuit was filed. And like you said, we got caught in the crossfire. Musk's lawyers ended up trying to subpoena me for some of that material. And yeah, I mean, it's a funny story. I mean, I can go into that as well if you want, but
I am sure the journalists here would love to hear the story of how you got served. Or
I mean, long story short, it's not great getting a subpoena. I remember being at home that day, working from home, and we have like a small office in San Francisco with someone who controls the door, and our office manager kind of messaged me on Slack and is like, "You have a visitor here. Should I let them up?" And I kind of disregarded the message because I was working from home. And eventually the person gets let up and sits in our kind of lobby area for like 10-15 minutes. And someone messaged me again and is like, and basically says like, "You have someone waiting here for you." And I was like, "I have no idea who this person is. Like, I don't have any meetings. I'm working from home today." Mm-hmm. And then we kind of deduced that I think the person's like holding like a packet of papers or something. And someone eventually asked them, one of my colleagues asked them like who they're here and what they're here for. We kind of deduced that it's a process server, and there was kind of a flurry and an exchange of very colorful words by some folks in the office, and they eventually kicked him out. But yeah, I mean, it wasn't great, and we didn't. Yeah.
You physically to like walk through the door, or you to be in the office, and he was gonna like hand you these papers. That was.
I guess like in the movies where they're like, "You've been served," right? And that didn't happen because I was at home. Mm-hmm. But yeah, it was jarring. I mean, we didn't know who that was for or what case that was for. I think we may have known that the lawsuit had been filed, but like it could have been anyone, and so that just in and of itself is super jarring.
And so eventually they just served it on the company. They didn't have to find you physically.
I think we arranged it so they served, or we allowed for a lawyer to receive the subpoena on my behalf. I think that day, but it was like a whole day of like sitting on calls and figuring out what was going on, who was subpoenaing, that kind of thing. And yeah, it was more annoying than anything.
Okay. And like, how much did you personally have to sort of participate in like the legal wrangling around trying to quash these subpoenas? Did you talk with the attorneys a lot, or?
It was really handled by our in-house lawyer, Chris Hickman. And then we had Davis Wright Tremaine come in and represent us as well, Kate Bolger there. I think it was like, I mean, I was looped in on basic conversations about what was going on. They were really keeping me abreast of the situation, but I wasn't like, I was like leading our legal strategy here. But yeah.
What all did they want in these subpoenas?
That's the thing. I mean, they wanted a lot. I mean, so to be clear, both sides wanted to depose me in the case. Musk's side much more aggressively. They wanted beyond the emails. I think they wanted something like our ethics guides. They wanted discussions pertaining to the story between myself and the editors. I have to go back and look, but yeah, it was a pretty far reach in terms of like what they were asking for.
Mm-hmm, mm-hmm. And so I've dropped into the comments here your attorney's motion to quash the subpoena, and in that they definitely invoked the California Shield law, saying that there's no way that you need to be like testifying about your internal conversations at Buzzfeed with your editor about whether to run this story or not, that's all covered by the Shield law directly. And I think they also went into that it was just irrelevant to the case at hand, given this was a defamation suit and it was already on the public record what your story said. So what more do they actually need from you as a reporter about this? You're not the one being sued here.
Right, right.
And then also that the only point of this was like just to harass you or retaliate against you for writing this story in the first place.
Yeah. I think one of the strongest points that was made, I mean, like, yeah, I mean, one of the points that was made was that Elon has the same emails that I have. Like, if they're worried about the correspondence that we had, it's all there for everyone to see. We ended up publishing all the emails so everyone could see the reporting process. I think what, I guess, bothered Musk's side the most was this discussion of on the record, off the record. And they wanted to use that as a kind of wedge to get into the reporting process. But as I said earlier, I think we were all above ground in terms of never having established off the record and that being fair game. So yeah, that motion to quash from Kate and Chris is really interesting reading.
So then the actual outcome was the judge did quash Musk's subpoenas. Did you go to those oral arguments at all in the city, or?
No, I didn't. I didn't go to those. And yeah, like you said, it was actually interesting because the case was in LA federal court, but my subpoena case was dealt with up here. But yeah, I didn't go to those oral arguments. Okay.
And while this was going on, did it at all affect you in your ability just being a reporter in technology, or did you continue to cover Tesla during this wrangling?
I did cover Tesla. I mean, it's interesting because I don't really have like a beat at BuzzFeed. I don't cover Tesla or any one company, but I did continue to cover the specifics of what was happening. I mean, it was a really interesting case, super newsworthy. It's not every day that you see a billionaire CEO get sued for defamation for something like this, for something he said on Twitter, for example. So we continued to cover the case, and we actually broke a bunch of stories on it with regards to like where Elon was getting this information from, for example, which is a fun story to follow.
Okay.
Yeah.
And throughout that, were you continuing to send Elon emails for for asking for comments on your stories?
I think maybe at one point. I don't think we ever got a response, but yeah, I mean, I think the the point is like, yeah, I mean, it was, you are kind of thinking about stuff twice, you know, you're looking over your shoulder, making sure everything is like super careful. And like, that is, I guess, one of the impacts of being subpoenaed in a case like this. You know, it's like, it is chilling in some ways. So yeah, it wasn't, it's not a recommended experience, I guess. I wouldn't like going through that process again, for sure.
And then you did cover the actual defamation trial in Los Angeles, right?
I did, yeah. Yeah.
Can you talk to us a little bit about your experience? Did you see Elon or have any interactions with him at the trial?
Yeah, the trial was at the end of last year. It was like a week long. And I mean, it's rare that these cases even go to court. Like defamation is like usually settles. He didn't settle. So I went down there and covered the case. I did have a bit of interaction with him in an elevator at one point. I tried asking him questions, but he was like playing a mobile game on his phone and didn't really want to engage with me. It was on like the last day of the trial. But yeah, that was super interesting to cover, especially since he ended up winning his case and was not found liable for defamation.
And I think I read your story last night about covering the case, and you said that during the trial itself, like the lawyers would give you knowing smiles when your stories came into evidence.
Yeah, I didn't love that either. I mean, it's like, it's weird. You're sitting in the courtroom and like the emails were read aloud to the jury, you know, and they're like reading like every single like grammar mistake that you have, like, and like it can feel like the shifting of the seats as like other journalists like realized that those were my emails eventually, and then they started like turning around and like I read one story where it was like that they like wrote about like my reactions to the email, which I thought was like really bizarre and just like kind of uncomfortable. But
what they say your reaction to the email was?
I think it was like squirmed uncomfortably, which is like, I mean, like, I don't know how you react. Like, am I supposed to like sit like dead still? But yeah, I don't know. It was surreal. Yeah.
And you still cover Tesla and Musk to this day?
Yeah, we write stories about Elon Musk and Tesla and SpaceX. I've written a couple recently about how the company kind of flaunted Alameda County shutdown orders for its factory, for example, during the pandemic. So yeah, we're still continuing to cover the company and we'll continue to do so.
Do you still email Elon directly or?
I try. Yeah, I mean, it's his email's right there. Why not shoot him a request for comment? But if he responds, you'll see it in the story. Yeah.
Let's see, do we have any questions from the audience for Ryan?
I see one about Elon might be listening to this. Did he tweet something just now? So the funny thing about Twitter and Elon is that after the trial, he also blocked me. So every time I see a tweet from him, I have to open up a incognito window to actually view what he's saying, which is like a really annoying process. So I'm like trying to take this tweet that Matthias dropped in the channel and like just to read what he said. But
let's see, Matt's asking, as you continue to cover the story, did you find that all the sharing of these exchanges, the email exchanges, helped lead to additional sources who were perhaps more willing to talk to you?
I think it just the notoriety of it, right? Like, I think people were just kind of like amazed that he would do something like this. And so that notoriety just brought more attention, which in turn brought more people to email me or message me. So yeah, kind of. I also got a lot of trolls. There's a lot of people that defend Elon Musk online. So there was kind of a flurry of abuse as well. So you kind of get both sides.
Mm-hmm. Has this changed anything in like, just as far as a journalist, when you're writing emails to people to let them know, like, look, you're on the record until we have a conversation about not being on the record? Like, have you at all changed your practices because of being in this situation?
I don't think so, but I mean, like off the record, on the record is like, it's like, there's no like codified law to it. And like the way we approached the Musk thing was that, I mean, here was something that was incredibly powerful, just kind of mouthing off, I guess, unwarranted about someone who was more or less a private person, you know, and trying to kind of spread misinformation about him. And so that's why we kind of assessed that as like I mean, it was on the record. There was no agreement, period. It was on the record. Would I do that again? Like, I'm like, maybe, like, I think it's a case by case basis, but like, yeah, I think we're completely in the clear with regards to publishing that.
Mm-hmm. Do any of the lawyers in the room want to comment on this case or have a question for Ryan at all? I mean, one thing that was interesting to me in all this is in your attorney's arguments, the fact that just any conversation you have with your editor is basically protected by the Shield law within the newsroom. Like, you cannot be made to get on the stand and talk about why you decided to run a story or write it the way that you did. So that was the one interesting thing, though, is that the judge in the case, if you check the judge's order, they did not actually even go into Shield law.
Right.
They finally just said this is not relevant to the case at hand. And they, for Musk's subpoenas and for the Cavers, they said, well, you can ask him about these two very, very precise things. And it was honestly just not a whole lot. And they just gave up, right? You didn't get deposed by Unsworth either.
I can't remember. Yeah, I think they might have signed something small, like a couple of questions. But like, to your point, like, I think the judge in reading some of the arguments was that like, it wasn't like Musk was suing me or I was suing Musk. I wasn't a party in this case, right? And so in making that argument, like, it wasn't, she didn't even broach some of the subjects because of that kind of conclusion that she made, basically. So yeah, again, not fun to go through.
We have one more question here from Ginny. Ryan, did you think much about the Shield law and reporter's privilege before you got hit with a subpoena?
Honestly, no. It's like, it's not one of those things you think about like, I don't wake up every morning and be like, I'm going to read the Shield law today. And it's just like, I know that it exists and it's there. And it's for great lawyers to parse and protect us. But yeah, I didn't know the nitty gritty of it. Clearly learning stuff today as I sit on this panel, listening to smarter folks than me like talk about it. But no, I've learned a lot going through this process, that's for sure.
And did you at all suspect you were going to get pulled into this as soon as you saw this defamation suit that now Elon was getting sued? Were you like, oh man, this is me?
The funniest thing when the subpoena came in was like, colleagues like speculating like, who is it? Like, who, like, maybe it's Musk, but maybe it's Mark Zuckerberg. Like, it's like going down the list of people you might have like pissed off. But like, yeah, I mean, I guess there was an inkling in my mind when it happened. Again, I don't know, because like, we were so public about like, and purposeful about publishing not only just the story and every like phrase in that email, but also the emails themselves. Like, we were very clear about like our deliberation and showing our work, basically, in our reporting. And so we were like, what else could he want? What else could people want here? If it does come to a situation where I do get subpoenaed, but it still happened anyways. And thankfully we were more or less prepared for it.
All right, well, see, no other questions. I think we're ready to wrap here.
Yeah, well, so thank you all again so very much for being on our panel, and then to everybody that joined, really appreciate it. We did circulate in the chat, and I think we will also circulate by email how you can get more involved in FAC if you wish to do so, how you can sign up for SPJ NorCal if you wish to do that. But Christine, Lauren, Aaron, Ryan, And Vicki, thank you so much for taking the time to do this. It's really, I think, crucial part of what FACT does, and I think really important for journalists to have some awareness of the protections that they have. And I think the vast majority of journalists are like Ryan. They don't know the ins and outs of the SHIELD law, and there's no reason that they should. What they should know is that if you get a subpoena or you get somebody asking for information, you should reach out and find a lawyer to help you work through it, because it can get kind of complicated. Although it's the protections are very clear in California, it can get complicated. So it's good to have a lawyer to guide you through that. So again, thank you everybody, and thank you for all who joined us for this program. And there we are at 1 o'clock.